Yeah, I'm Larry Tribe. I guess my official name is Laurence H. Tribe, and I'm the Carl M. Loeb University Professor at Harvard Law School and Professor of Constitutional Law. I think in some ways the most significant case that I handled as a lawyer in the Supreme Court or anywhere was the first case that I handled, and that was called Richmond Newspapers against Virginia. I hate to say that it was all downhill from there, but in a certain sense it was. That's a case that, for the first time, established as a matter of federal constitutional law that the press and the public have a right to observe and be present at the kinds of hearings, primarily criminal trials, that are traditionally open to the public, that you cannot simply exclude the public on some excuse that they would be embarrassed or that witnesses might be squeamish or that maybe somewhere along the line a secret would come out. I mean, you can block out people's faces if they need privacy. You can do various things, but you can't close the proceedings. It was a great case, and it established a principle that I think is vital not only to the rights of the accused, because this was not a case where the accused wanted the public to be present. On the contrary, he was very happy to have the proceedings closed. So was the prosecutor. So was the judge. They were happy to have them closed because after several missed efforts to convict him, there was some kind of deal whereby he was acquitted. And even the family of the murder victim didn't get to see what happened. They got to read a cold transcript, which was little solace later on. But it's really vital for the interests of victims, for the interests of the public generally, to know what's going on in these important trials that establish a great deal about vindicating principles of justice. So that was a great case, and I was very glad to have handled it. Another case, great in a very different and more limited sense, was a case that began in my own backyard. It was a case called Larkin v. Grendel's Den. There's this little pub in Harvard Square where people can have lunch and a drink. And I learned when I was teaching constitutional law that they couldn't serve drinks and were likely to go out of business because a nearby church had vetoed their liquor license. And I thought that was outlandish. How could a church be given the power to regulate the local economy? I mean, there were hard cases about church and state, like what kinds of prayers at a town meeting may or may not be allowed, or whether a menorah has to be next to a Christmas creche in order to make a display at Christmas sufficiently secular. But this was an easy case, and yet the law of Massachusetts had said churches have this power. So I worked with the student who had called it to my attention when he wondered why he couldn't get a drink with lunch, and I worked with Justice Stephen Breyer. Needless to say, he wasn't yet a justice, or I wouldn't have been able to work with him. He helped me put the case together. We argued that it violated both the antitrust laws because of the anti-competitive nature of the deals people could make as to whose liquor license would be granted and whose would be denied. And more important, it violated the separation of church and state, the Establishment Clause. And 8-1, in a wonderful opinion by Chief Justice Berger over solely the one dissent of Justice Rehnquist, the court said that this is a fundamental violation of the separation of church and state. Justice Rehnquist's dissent was based on the idea that since you can have liquor-free zones around churches and schools, you can do this as well, because after all, more kids can get a drink in Harvard Square if at least there's a chance of getting the church to say okay. But that didn't make any sense to me, and it didn't make any sense to the court, because the right that I was arguing for was not the right to get sloshed over lunch. It was the right not to live under the thumb of someone you didn't elect, the thumb of a religion that you may not believe in or belong to. So that was an important case. Of course, everybody would expect me to mention Bush v. Gore, but I think it's more interesting to know that cases that are less notorious can sometimes make a huge difference to the quality and the nature of our lives. Well, I doubt that Bush v. Gore will go down as the court's proudest moment. It's not so much that the Supreme Court got involved, although I have argued, and I think many people believe, that it had no business getting involved. It was a process that was already underway. The Supreme Court of Florida had mandated a recount of ballots in accord with Florida law. But okay, so the Supreme Court gets involved because it looks like a mess down there. It looks like the ballots are being counted in different ways in different parts of the state, maybe arbitrarily. Some people will remember the odd pictures of people holding up paper ballots to see if the little hole was punched all the way through or not in order to read the intent of the voter, an obviously difficult thing. And actually, in the end, 7 justices did agree that the process was so ununiform that it didn't satisfy requirements of equal protection. Now, that involved a very novel use of the Equal Protection Clause. It did not involve the use of the Equal Protection Clause to protect racial minorities or even to avoid discrimination along racial lines or along any other suspect line. No one thought that the process in Florida that was going on was anything but chaotic. That is, no one thought it was a deliberate scheme to deprive George Bush and his voters of the election. But put that aside for the moment. The real problem was not the court's 7-2 holding that a better and more uniform voting system had to be engineered. The real problem was the decision by the court, before it even heard argument in either of the 2 cases that are generally understood to come under the rubric of Bush v. Gore, one of which I argued and the second of which David Boies argued. But it was the decision by the court to halt the counting completely while the court took the case under advisement. Well, at that point, it really looked like the matter was over because the clock was ticking, the court was concerned about deadlines. In the end, the court decided 5-4 on the basis of a really bizarre reading of the relevant legal documents and the relevant laws of the United States and of Florida, that it's too bad that we can't have a uniform count of all the ballots and a uniform recount now that we're recounting, because it's too late. There are only a few hours until the deadline. Now, it was really months until the actual deadline. The president wasn't going to be inaugurated until months later. It wouldn't have been hard for the court to say, now that we've told you what's wrong with the method of counting the votes, do it right. But instead, the court took upon itself the task of calling a halt to a national presidential election, essentially determining the outcome by a mere 537 votes out of the millions cast in Florida, and thereby determining Florida's electoral vote and thereby determining the outcome of the entire election. For the court to do that really involved a deep problem, and the deep problem was this. The underlying rationale of the decision was votes should all be counted equally. Well, how equal is it if you stop counting before you've finished whatever counting process you're engaged in? That's an even more egregious and gross inequality than having slight variations between North Florida and South Florida. So I think the court did itself great disservice. Now, ironically, even though Justice Stevens and other dissenting justices predicted that the court's reputation would be badly tarnished by the decision, polls show that, on the whole, respect for the court has gradually declined over time, but not sharply in response to Bush v. Gore. And in fact, even now, when so many more people think the court is leaning conservative, in some senses of that term, more than liberal, it turns out that more Republicans than Democrats have a diminished respect for the court. Democrats tend to think it's not all that bad. So the court didn't do itself the kind of demonstrable institutional damage that I think many predicted, but I think it hurt its reputation, and I think it performed a national disservice by taking the power away from the voters.